Thank you. I'm Mark Rosser with First American Title. I'm honored to be here. I want to thank TLTA for letting me come. I want to thank each of you for your support for TLTA. This next session is entitled Resolving Common Title Issues. Most of you out there are smarter than me, and you know right up front that we're not going to resolve a lot of them. But we're going to talk about a lot of them, and what I want to do most of all is enter into a thought process with you. Kind of give you an idea of at least how some underwriters approach some of the questions that we get. Now, let me encourage you on the front end. We're going to cover during this time several issues, but I want you to jot down. If you've got an issue or a question that you would like covered, jot it down. Later on in the session, we'll save a little bit of time. If we've not addressed something you wanted to talk about, then holler it out and we'll give it the get-go. But at the beginning, let's have a little fun just for a few minutes. Some of you may have seen part of this before, but I read the other day that there's something like 30,000 words that have been added to the dictionary the last few years. A lot of them have to do with technology. But I want you to know that there are some words that haven't been added that need to be added. That's the bio. You can read that in the materials if you want to. But for instance, castration. Anybody familiar with castration? The act of buying a house which renders a subject financially impotent for an indefinite period of time. Okay, so have any of you ever dealt with anybody that's been castrated? Okay, you'll know what it is. Okay, reincarnation. Anybody have any idea what reincarnation is? And you may know somebody here too. They're coming back to life as a hillbilly. That's where you've been reincarnated. Intoxication, very timely this time of year. The euphoria at getting a tax refund, which lasts until you realize it was your money to begin with. That ever dawn on you when you get your tax refund that it's really our government giving you your money back? All right, and then the last one we'll look at the beginning is boson. Now, you know, we hear a lot about climate change and the ozone layer. I think boson is even more critical. It's the substance surrounding stupid people that prevents bright ideas from penetrating. Unfortunately, the boson layer shows little sign of breaking down in the near future. So, can I have a show of hands of anybody that knows anybody enveloped in the boson layer? Okay, that's all right. No names, please. We've got one more we'll look at the end of the show. It was the prize winner, I think. But also, before we start, we're going to talk just a little bit about history, because I think it's very important and timely that we be reminded about how important it is in terms of the job that we do, the industry that we are in. Anyway, any of you legal scholars out there familiar with the name William Blackstone? His commentaries are really the basis for the American common law system. He was an English jurist from the mid-18th century, and this from his third commentary. The third absolute right inherent in every Englishman is that of property, which consists in the free use, enjoyment, and disposal of all his acquisitions without any control or diminution, save only by the laws of the land. The laws of England are therefore, in point of honor and justice, extremely watchful in ascertaining and protecting this right. Upon this principle, the Great Charter has declared that no free man shall be disseized or divested of his freehold or of his liberties or free customs, but by the judgment of his peers or by the law of the land. Okay, let's think just a minute. What was the side profession of our first president? Surveyor. All right, do you remember a few years after that, how did we help settle states in the Midwest? You remember? Remember something called homesteading from your history, where if people went out and settled in an area, what were they granted? Granted land. specific parcels of land. Is it 140 acres? I can't remember exactly. But land has always been crucially important in this country. And not only that, the land record system. In fact, I would go so far as to say that the real driver of the American economic system is the land record system. And I'll think just a minute about what real property does. You know, we talk about home ownership and we talk about the pride of home ownership, and that's certainly true. But that's only part of it. You know, when you buy a home, even if you mortgage it, you're really getting into a forced savings account. And what's the savings? The savings is the equity in your home as you pay your mortgage down. I won't ask for a show of hands, but how many of you perhaps have given a second mortgage on your home which enabled you to buy another piece of property or buy an office building or expand your business? See, this is how our economy is driven, and it could not be driven without the land record system that we enjoy in this country. You know, as underwriters, we are involved in many countries around the world, but we can't be involved in all of the countries because many nations do not have land records sufficient to allow us to insure titles. But we do in the United States, and it is absolutely crucial. So what you do every day, you know, I know it's to us, it's a business. We want to make a living. We want to expand our business. But it's also absolutely crucial to this country. Because if the land record system breaks down, then the whole economy follows soon thereafter. What you do is important, and never, never forget that. Okay? Now, ultimate goals in our profession: to protect the integrity of the land title system, and then the land record system, and then, of course, because I work for an underwriter, to produce an insurable title. Okay, let me ask you a question. Can or do these goals ever conflict? Anybody? Can they conflict? All right, how can they conflict? You know, we might choose to insure over a defect in the title if we think the risk is something that we can control. So see, you've got twofold goals. Sometimes they conflict, but ultimately what we're wanting to do is make, if possible, the real estate to be marketable. Okay? Now, remember, a title insurance policy does not guarantee a clear or clean title. That surprise everybody? It's not what title insurance does. Rather, title insurance is a contract of indemnity that pays for loss or damage resulting from covered items in the policy. And covered items in the policy are what? The covered risks in the policy, minus the exclusions from coverage, minus the exceptions, and plus the endorsements. Okay, let's think just, you know, if you haven't done this or you haven't done it in a long time, and I know it's boring, but some night when you can't sleep, pull out a title insurance policy. I guarantee you that'll do it. But in the meantime, the first thing that you're going to see in the title insurance policy is a section called covered risks. Now, this is important because in the 1992 form out the policy, which we used for many years, there was what, 7 or 8 covered risks? And now, I think in the owner's policy, there's what, 17 or 18, and in the loan policy, there's 25 or 30. You need to read the covered risks to get a good handle on what our product does. I mean, sometimes it's obvious to us, but sometimes it's not. How many of you have gotten a call from somebody whose hot water heater went out? I'm serious, and they want to file a claim under their title insurance policy. Okay? I mean, you know, to us in the business, we say, well, you know, that's obvious. But you want to look at the covered risks in a policy to start with the broad parameters of what our product does. Then you go from the covered risks. We have a section called exclusions from coverage. And there's some exclusions from coverage. These are in the boilerplate sections. You know, one of the exclusions is something created, suffered, or assumed by the insured. Okay, that one's very well known. But many zoning and subdivision items are in the exclusions from coverage. Sometimes people aren't aware of that. That's why on a commercial transaction, you may be asked for a zoning endorsement to put it back in. Otherwise, the issues of zoning are not even covered by your basic policy. Then you have your exceptions, your Schedule B exceptions, and then you look at your endorsements, which are coverages added back in or altered by agreement. So, that's just a basic foundation of getting a handle on what our product does. And sometimes we're in so much of a hurry that we haven't taken the time to glance at the policy and see what it really does. Now, as agents, as practitioners, when you're dealing with a real estate transaction, and you find a problem, one item, before wearing yourself out with the issue or problem you have discovered, find out if the owner-seller has an owner policy and get a copy. An owner policy may allow you to proceed despite the problem. Okay? Everybody aware of that. Cynthia mentioned that. But to me, when we give seminars, and sometimes agents, and you can do this as an agent, contact your underwriters and invite your underwriters to come out and do a dog and pony show for your realtors and banking friends. And just talk about title insurance, or use some of the materials from Alta that Cynthia mentioned in the last hour. When people think about title insurance, you think about a product that covers the insured from past problems in the chain of title. Well, certainly that's true. But people forget that one of the best guarantees of future marketability of your property is having an owner's title insurance policy. Easy example, we run into it all the time. Person buys a home in 2012, the title is clean as a whistle, and the realtor or the lender or somebody's told that person, you don't need an owner's title insurance policy. And he says, well, I know that because I've known that family for years. And so they buy the property, they don't get an owner's policy. Once more, the title is clean as a whistle. 3 years later, that insured goes into refinance. And what do they find? They find that the mortgage that was paid off when they bought the house in 2012 hasn't been released. Okay? You contact the agent, that agent's no longer around. Or their files are in storage. Or they've lost the files, so they can't produce the evidence that the mortgage has been paid. Meanwhile, the borrower is sitting there watching his interest rate lock run out, where if he had had an owner policy, most likely you could have gone on and insured his refi under what we call the mutual indemnification agreement between the underwriters. Everybody follow me? See, this is protection under an owner policy, not for something that happened 20 years ago that was missed in the title. This is protection regarding something that happened at the closing table. Just the seller's mortgage. Yeah, the seller's mortgage. Everything goes, and probably it was paid off. Absolutely. And so your owner policy, and so let me stop just a minute. In your materials, because the PowerPoints are not in the materials, there's three main things in the materials. The first thing in the materials is a set of materials on estate matters. We call it Dealing with the Dead. That's just something for your reference. I encourage you, if you look at that, to look at the beginning, because you're going to see in the explanation on it when I put it together that I said sometimes I sacrifice technical legal accuracy for understandability in terms of working with issues. It's not intended to be the Bible, and I know a lot of you, of course, work with other underwriters, but you will find in the materials at the end copies of just about all the statutes involving probate matters in Tennessee. So it should be a handy resource. Also, if you look in the definition of death taxes, I think we've outlined the various inheritance tax exemptions that were in play for the various years until it was eliminated a year or so ago. So you're going to have, we call it Dealing with the Dead. estate materials. After that, you're going to find the Tennessee Mutual Indemnification Agreement. Now, this is the treaty between the underwriters. And this is the treaty by which we have agreed to indemnify each other under certain circumstances. Now, first of all, the general rule is you don't want to rely upon the Mutual Indemnification Agreement without your underwriter's approval, okay? Because there's some exceptions to it. But I put it in the materials because I wanted you at least to be familiar with it, because sometimes you'll hear that mentioned. You'll hear it referred to as the MIA or the Mutual Indemnification Agreement. And so it's in the materials, so you'll get an idea of what we're talking about. And then the last thing in the materials we slipped in was a copy of the ALTA 34 endorsement. Right quick, this is your quiz for the day. Anybody know what the ALTA 34 endorsement is? I'm sorry? All right. You win the prize. The ALTA 34 endorsement is the endorsement designed by ALTA just a few years ago to be used when you are giving affirmative coverages or insuring identifiable risks. Now, sometimes your underwriter will help you create some affirmative coverage language, but more and more, most people are going to the ALTA 34 because it has a lot of basic provisions in there. It talks about attorney's fees. It talks about marketability. And, you know, we will make reference to this later on, but it's good for you to be familiar with the ALTA 34 if you are not already. Because, let me say this, we call this the golden rule of underwriting, okay? You know, you want to treat your customer as you would like to be treated. So, if you were buying a home, or doesn't have to be a home, if you were buying a parcel of real estate, and you were getting title insurance, and let's say there's a technical defect somewhere in the title, but the agent has the ability to insure over that. As the purchaser, wouldn't you want to know about that? I mean, you're buying it. You know, it's your property. And so that's what the ALTA 34 does. It's a means of identifying the risk, identifying the affirmative coverage. It's attached to the policy, and that way the homeowner, the insured, is not surprised later on. One of the common ways this comes up is just on one of these unreleased mortgages. Maybe your underwriter has given you permission to insure over it. So you insure the new lender without exception, but you really should be insuring the buyer affirmatively. But let's say you don't mention it to the buyer. So later on, the buyer goes into his local rural bank to get a second mortgage. And that local rural bank doesn't really deal in title insurance. So they have their local attorney do a title search. And what does that attorney find? He finds the unreleased mortgage that the buyer knows nothing about. So the buyer's mad, the buyer's in a panic, the buyer calls you, and you know, you can say, well, we insured you over that. Well, yes, but you didn't tell him about it. And see, that's what the ALTA 34 or affirmative coverage does. That way the buyer's not going to have surprises later on when he's mortgaging the property or refinancing or selling the property. Yes, sir? Well, no, not if you look at the ALTA 34. And so that's why it's very important to get familiar with that, because it brings it to the forefront, and it binds the insurer to either insure again or pay if nobody will insure, that type of thing. It also talks about attorney's fees. It's a real good endorsement, and that's why most people are gravitating toward it rather than just making up their own language for affirmative coverage. Okay, get familiar with the 34 endorsement. Okay, executor authority. Other than unreleased mortgages, what is the single most common underwriting question? We don't have a scientific study on this, but I would vouch to say that whether the executor or administrator has authority to sell real estate without joinder by the heirs or devisees. My goodness, I wish I had kept a diary of how many wills I've read the past number of years. And some of the wills even made sense. So don't you dare quote me on that. And this is the one that comes up time after time after time. The agent emails the will and says, does the executor have authority to sell? And it also makes attorneys mad at us. It makes agents mad, puts everybody in the middle. And what I want to do for the next few minutes is kind of draw you into the thought process about why we have this particular issue. I know that's small print, TCA 31-2-103. Let's just particularly pay attention to what I've highlighted in red. The real property of an intestate decedent shall vest immediately upon death of the decedent in the heirs as provided in 31-2-104. The real property of a testate decedent vests immediately upon death in the beneficiaries named in the will, unless the will contains a specific provision directing the real property to be administered as part of the estate, subject to the control of the personal representative. Okay, this is the vesting statute. And I dare say a lot of attorneys that draft wills have no idea this statute exists. I'm serious, and it is very, very, very clear. So let's just break it down. What does this statute say happens when somebody dies? Regarding the real estate. It vests immediately in the heirs at law if there's no will, and if there is a will, it vests where? In the devisees. I mean, it just flat spells it out. And then it gives an exception where you can add that statutory language, and most underwriters are going to bend if they can. You know, if you've got language similar to that signifies the intent. But this is where we start. You know, when we talk about does the executor have authority to sell, this isn't something that we're making up. It's statutory. Now, interesting too, that this is kind of I don't know, I call it a trick question. But it's easy when we say intestate, but on the real property of a testate decedent vests immediately upon death in the beneficiaries named in the will. Does it say in the probated will? No. It says in the will. Now, you can make an argument that until the will is probated, it's kind of akin to an unrecorded deed. So you've got other issues there. But this vesting language is very clear. So, if the executor or administrator only controls assets of the estate, how can she control or sell real property when it is already vested in the heirs or devisees and is thus not part of the estate? See, that's the whole issue. That is the whole issue, is that the previous section that we looked at takes the real property out of the probate estate subject to certain exceptions. Then you go on, unless the will provides that the real property shall be administered as part of the estate, then the executor has no authority over the real property unless the personal property is insufficient to pay lawful claims and expenses of the estate. Okay, and then there's a procedure that you go through, and I'm not going to wear you out with the procedure, but basically what you're dealing with there is an insolvent estate. And let me mention again, in terms of practice, that there's probably more estates that are insolvent than people realize, technically insolvent, because insolvency is just based upon personal property. I like to tell people that I could own Biltmore Mansion, free and clear. But if I died without a penny of cash, I've got an insolvent estate. Because Biltmore Mansion, I don't know what's worth, $1 billion, I have no idea. But unless I have personal assets sufficient to pay my lawful claims and expenses, then I have an insolvent estate. So there are sometimes situations where you will have a technical insolvency. Maybe you've got multiple heirs, multiple beneficiaries or something, and you'll be able to get back to the personal representative having the authority to sell, but you're going to have to go through a proceeding to get there. You're going to have, in effect, something akin to a finding of insolvency. Then the property's brought back in. Then the court can order the sale of the property. Stop just a minute. Yes, sir. Okay, excellent point. Exceptions. All right. If the will directs that the real property be sold, that's an exception. The general consensus is that a sale directive includes the authority to carry out the directive. Now, I'll tell you, sometimes you're going to get underwriters that differ on that. So I'm just mentioning that that's generally an exception. I would treat that as an exception. You definitely would want to take that to the underwriter. But the idea there is that if the decedent has specifically said, I want Blackacre to be sold, then we think that carries with it the authority of the executor to do that. Okay? Number two, now here's where it gets tricky. And, it depends on whether you've got one of those diehard Republican conservative underwriters or one of those blue liberal underwriters. You get into wording of the will. If the will states that the executor has authority to sell any real property, quote, which I own at the time of my death. Note that this language is different than stating that the executor can sell any real property of my estate or any real property comprising part of my estate. Now, we're splitting hairs there, but I'm trying to get you inside the mind of the underwriter when these questions come up. A lot of times you're going to see language in the will that says, my executor can sell any property of my estate. Well, what did we learn by the previous statute? The real property's not in the estate. So that language doesn't help. Now, personally, my personal opinion is I'll bend more if the will specifically says, which I own at the time of my death. I mean, it's a different emphasis. And let me tell you what we'll do. We'll look at the entire set of circumstances. And now, just so you don't think we all just sit inside a room and try and figure out ways to turn deals down. As underwriters, we only get premiums if you sell policies. So we're all in this together if we can make the deal work. But let me give you an example. Let's suppose we've got a will that says that it divides some of the personal property. Then it goes down and said, I want the residuary of my estate to go to. And it lists about 10 different devisees. A few of them are churches or nonprofits. And the person died owning one piece of residential real property. Okay. Now, if I'm sitting there as an underwriter, I'm thinking, the devizee really did not intend for all 10 people, the decedent did not intend for all 10 devisees to own that real property as tenants in common. I mean, you might have 3 churches, you might have Salvation Army, you might have United Way, and then you might have several individuals. In a situation like that, I'm going to bend over backwards to try to find something in that will I can hang on to let the executor sell the property. Okay? Because I think that's a practical way to look at it. But on the other hand, bear in mind what the technical law is. And the technical law, would probably read in some of those situations if that real property vested immediately at death. So that's kind of the bind that we get into sometimes. And that's where we come down to evaluating risk. Okay? So if I've got a borderline will and the residuary clause or the real estate goes to my 4 kids, 2 of them are co-executors and 2 are not, and the wording is borderline, I'm probably going to want all 4 of them to sign, because I don't want to step into the middle of a family dispute. Okay? On the other hand, the situation I just had, if it's borderline and there's 10 devisees, and some of them are nonprofits or churches or whatever, and we're dealing with one parcel of property, I'm sitting here thinking, those entities do not want to be tenant in common owners with the others on this piece of property. What they want is for the property to be sold, and they want to get their share of the proceeds. So I'm going to look at it from that point of view. But these are the issues you run into, and particularly, I mentioned at the bottom, but simply granting the executor all powers set forth in TCA 355110 is not sufficient, even though that statute includes the power of sale because it does not supersede the previous statute. And more often than not, that's the language that you see. You don't see language that says, I want my real property incorporated into my estate and treated as personal property under the control of the personal representatives. It says, I give the executor all authority set forth in TCA, and that's where we end up making people mad. Okay? So, people have an idea of what we're dealing with there. Okay, let's see what's next. Estate? Yes, sir. Yeah, and the question is, you have a situation, and I'm not putting words in your mouth, but I call these orders of convenience. We will be presented an order. Somebody will say, well, we didn't have the proper language in the will, but the agent will say, but they've got a court order to sell. And it's an order of convenience. It really doesn't give a statutory basis for incorporating the real estate. It just says, we hereby decree that the executor can sell Blackacre, yada, yada, yada. We turn those down, and we've made people mad. And let me mention, and I was in this world too, although it's, time has continued to pass. In my private practice days, you find, and I want to be careful how I say this, but particularly in rural counties, a lot of probate judges will sign most any orders that their friends in the bar bring to them. Okay? And let me hasten to say, people aren't being unethical. I'm not talking about that at all. They're just wanting to make a deal go through. It's not a matter of somebody trying to steal money or whatever. But on your specific question, if there's no statutory basis for the order, we feel like we're stuck. And in the estate materials, at the end of those materials, you'll find copies of all these statutes. And basically, these statutes, that sometimes they don't use the term insolvency, but that's what it boils down to. You've got to have some sort of showing that the personal property is insufficient to pay the claims and expenses of the estate. Now, let's say you're dealing with one that you're trying to close and there are estate claims. From an underwriting point of view, we're going to look at, has the claim period expired? Do we know everything that's out there? Or are we still looking at a moving target? Will all claims be paid from the sale? If the claims period is expired and all claims will be paid from the sale, that's making it fairly straightforward. Is the estate insolvent? Okay, there's a lot of claims it probably is, but that's going to bring you back in for a specific court order which will protect everybody. And 4, is it a fair market value sale? Those are the types of things we analyze. And, a lot of the time, we can allow a transaction to go forward with an escrow of the net proceeds or payment into court if, particularly, we know that it's a fair market value sale. And the reason is, generally speaking, claimants aren't after the real estate. What are they after? They're after the money. And you're really doing them a favor if you reduce the real estate asset to cash. And it makes it easier for them to then argue over it. So there's ways to deal with these things, but most of the time they're going to involve some sort of escrow procedure. Generally, if the estate is insolvent, you can obtain a court order as such, bring the real property into the estate, and have the court order the real property be sold with the net proceeds paid into the court for further distribution. Okay? Everybody's protected there, and then they can fight over the cash. Let's see what's next. Okay, let's go back a minute. Let's stop here now. I have not spoken about anything about TNCare. That's a world of its own. It is addressed some in the materials if you want to look at that. Any other quick questions about estates? Yes.
Item number 2 is clarify as a settlement agent, you don't want us actually paying claims from the proceeds. If there are claims against the state that put excess proceeds over to pay off taxes, that sort of thing. So you let the court handle that.
Yeah, and let me say, every now and then we'll have a clear-cut exception to that, where the claim period is long since expired, and you've got a small unreleased claim that you can just pay out of closing. But generally speaking, you want the court to handle those, because you don't want to get yourself in the middle of a potential fight over claims and expenses and who gets what. So, okay, other unreleased trust deeds. That's probably the number one question we get. Hey, we got this transaction, it's closing in 15 minutes. Can we insure over such and such? And then somebody's out there saying, oh, you give him 15 minutes notice? Wow, we don't do that. I'm just put up here some of the things that we look at. In the trust deed, is there a stated maturity or facts from which the maturity can be calculated? Okay, you know what I'm talking about there. It may say due and payable January 15th, 2005. Or it may say, and these are usually older ones, payable in 240 monthly principal and interest installments beginning the first day of January 1990 and continuing until paid in full. There you can calculate a 20-year payoff to 2010 and analyze it accordingly. But if it says it secures $250,000 according to a promissory note of even date, the provisions of which are incorporated herein by reference, then you're stuck. You gotta do more diligence on that, because just not stating a maturity deed does not mean it's a demand note. Okay? Number 2, does the trust deed state that the debt is due and payable on demand? Sometimes they do. Promissory note of even date, due and payable on demand. If it is a demand note, then there is this 10-year statute of limitations from the date of the trust deed. So you can rely upon that. But just because there's no maturity stated does not mean that it can be considered a demand note. Okay? Number 3, is it a HELOC? HELOCs are bad news. As we all know, it's like whatever you try to get rid of that you can't, and it keeps reappearing. And I will tell you that the mutual indemnification agreement does not pertain to HELOCs. So if you're dealing with an unreleased HELOC where the statute of limitations is not expired, even if the current owner has an owner policy, you're looking at a letter of indemnity from the underwriter as opposed to just relying upon the MIA. Because HELOCs, again, can be a nasty business. Number 4, is there a possible balance due? See, this throws it out too. And I'm not being critical of anybody, but sometimes we'll get the email and they'll say, all right, we're getting ready to close this transaction. We've got an unreleased trust deed, but the seller's got an owner policy. Oh, by the way, we contacted the lender and they're still $7,500 over. Well, we're not going to ignore that just because there's an owner policy. And quite frankly, if you were buying property, would you want to buy property even if you got an owner policy where you knew there was a balance due on a prior mortgage? No. So, if there's a balance due, we're going to be looking at it different, probably requiring that it be paid off. That there could be all sorts of circumstances involved there. And then if no balance is due, you may be able to proceed if the seller has an owner policy. either via the MIA or LOI, letter of indemnity. Okay, this is common sense to a lot of folks, but just a reminder of what our thought processes are when you ask us. Broken priority, and we could go hours on this, I'm just going to touch upon it. Do you know what broken priority is? We're talking about in the construction lending business. Definition, when there has been, quote, visible commencement of operations prior to the recording of the trust deed. Okay? Generally speaking, that just stops everything in its tracks. Now, if this comes to an underwriter, though, we do ask certain questions. Number one, is the project residential or commercial? And we ask that for a specific reason, because if it's residential and the owner has hired a general contractor to build a home in which the owner will reside, there are certain statutory protections for the owner there that you don't find in another real estate transaction. And it may give you more flexibility, because in a case like that, the only folks that can file liens are those that have contracted directly with the owner. And a lot of times that's just the general contractor. You can work on waivers, subordinations, things like that. But it's still a long shot, but this is part of our thought process. Number three, check with your underwriter to see if mechanics and materialman's lien coverage is available via the Alta 32 endorsement, which has to do with incremental coverage. Now, let me tell you, that is a very complex endorsement. And I will tell you that many lenders don't understand it, because it provides for incremental coverage, but there are requirements that need to be met. And so I mention this because occasionally on a commercial project, your underwriter will get comfortable enough to proceed via Alta 32 coverage. It's very complex. We don't have to, it's a seminar all on its own, but I wanted to put it up there just so you would be exposed to it. Okay, a few more minutes. Property description errors. Anybody ever see a title search with a property description error? I remember one back in 1996, and if you believe that, there's different types of errors. Okay? Missing description, exhibit not recorded. Okay? Now, one of the things we're going to look at there is there anything else in the deed that identifies the property? Is there a tax map and parcel number? Is there an address? How much real estate did the seller own? Okay? Maybe there's ways to work around that. Maybe you can use a scrivener's affidavit if the preparer is still around. But this is our thought process there. Wrong property is described. Similar situation. It gets real tricky if the seller owned both parcels. You follow me? If the seller owned A and B, and you described A, but they should have described B, you're going to just about have to get a quitclaim deed back from the grantee on A before you can move on that. Once more, there's different exceptions here, but I want to give you the thought processes. Number three, line or lines omitted from meets and bounds descriptions or calls are reversed. Again, that never happens, but were it to happen, in my personal opinion, this is probably one of the least risky situations. Now, there's always exceptions. I mean, if the whole property description is garbled, that's one thing. But if you've got a 10-line meets and bounds description and somebody has omitted one line, and you can go back to previous deeds and just see where that one line was omitted, that really doesn't raise itself to the level of somebody else being able to make a claim on that property. You follow me? Most of the time, you can just correct that and move on. Same thing if you get into a property description where in the middle of it, they've reversed a call or two. If you can really figure out what they were intending, and once more, you're not aware of problems with the surrounding properties, we can generally work with those. I mean, they're sloppy. None of us like them, but, that's the way that it is. And, as an aside, when I was an old dirt lawyer, searching in those counties like Cynthia referred to. Years ago, I used to say at one point I had foreclosed from Mountain City to Music City. Anybody know where Mountain City is? A few of you do. You almost can't get there from here. Almost have to go up to Virginia, then go south to get there. And so, sometimes on those descriptions and so forth, now I've lost my train of thought. What was I talking about? What's that? Meets and bounds. And, most of the time, those can be fixed because you can figure it out. No, what I was saying is I went from private practice in First American. I get a call from a person, I won't say where in Tennessee, and they were just in a panic. They said, Mr. Rosser, we've got this closing coming up, and we don't have a description. We haven't received the description from the surveyor. I said, okay, so a survey's being done. She said, oh yeah, we've got the survey, we don't have the description. Which I know is commonplace now, but in my day, we never got the description from the surveyor. You got the plat, and then I'd sit down with my dictaphone and I would create the description from the drawing. Okay? Beginning at an iron pin at the corner of the intersection of such and such and such and such, and you'd go around and you would prepare your description. And this person was in a panic because they had the drawing, but they had no earthly idea on how to create a description. And so times have changed. And yes, get them from the surveyor if at all possible. But sometimes, you can easily see where something has been reversed. Erroneous lot number, plat book and page, or subdivision name. Most of the time, we can work around plat book or page or subdivision name. Lot number can be trickier. Once more, you're getting into, did the seller own both the lots? And you just kind of have to look at the whole situation. Yes. Grantee. Sure. Yes. The grantee giving up their right in that particular lot. And then the last thing on descriptions, description is too vague, multiple less than accepts, or bounded by description. As we tell our agents, underwriters most of the time on residential transactions do not require surveys anymore to give survey coverage to lenders. Good idea or bad idea, that's the way it is. But that does not mean that every description is insurable. And when you get a description that says, 4 or 5 acres more or less, bounded on the west by Thompson, on the south by Smith, it's just too vague. So, that's something to watch out for when you look at property description errors. Let's see if anything else. Foreclosure issues, we'll do this right quick. Okay. Appointment of substitute trustee not of record or recorded too late. Remember, with the proper language, the ALST only needs to be recorded prior to the substitute trustee's deed. So keep that in mind. You might want to write down that statute. And by the way, you can thank the TLTA for that savings statute that we put through several years ago, because we were running into a rash of those things. And so now, most of the time, the people in the foreclosure industry know the magic language to put in an AOST. So as long as it's got the magic language and it's recorded before the foreclosure deed, generally we can work with that, even if it's not recorded until after the publication starts. And don't ask me the logic of that. That's why we call it a savings statute. Notices to the IRS or state of Tennessee not recorded with the substitute trustee's deed. That's an epidemic. Just burns me up. You pay another $12 in recording, and look how many phone calls you save and time you save everybody else. But generally speaking, if you've got tax liens of record, you have got to be furnished proof that the proper notices were given. If not, what happens to the tax liens? They jump ahead. They become first. So that can be a biggie. One that yeah. Generally, if I can get a copy of the notice and satisfy myself that it was received in a timely fashion, yes, I can generally work with that. One that we see quite a bit, not as much anymore, correction, substitute trustees, deed changes the name of the grantee. That's another one that just burns the fool out of me. Most of the time, we're going to require a quitclaim deed. Now, you think about that. Somebody conveys property to MarkRosser. And then he says, oops, I meant to convey that to Jeff McCall. Well, MarkRosser may not like the fact that a new deed has come down. I mean, you follow me? I understand that generally this was just a mistake. But from the land record point of view, you're going to look for a quitclaim deed from the original grantee. There are exceptions if it's been several years and you look at the number of times the property's been transferred, and sometimes you can work around that. But again, this is our thought process. Substitute trustee's deed is recorded, and then the foreclosure is rescinded. And then a few years later, they're foreclosing again. You're going to look at that. You're going to look at the overall circumstances. Most of the time you can work with that. It really is disconcerting that we live in an economy where the Department A of the same lender can be telling its attorney to foreclose, and Department B can be working with the borrower for an extension. And A and B do not communicate. I mean, that is a very frustrating situation. And then the last thing, does it matter how much time passes before the substitute trustee's deed is recorded? No, not really. But I personally think at some point in time that's going to be a problem. And HUD has brought part of this on because sometimes they won't allow the deed, STD, to be recorded until certain things happen with the property. Meanwhile, you've got the borrower still getting notices from the HOA or whatever, the borrower saying, I've been foreclosed, and they say, well, nothing's of record. And we've seen these things go for more than a year without recording. And in the meantime, all sorts of other junk is recorded against the borrower. So technically, no, that number 5 is just down there for you to think about. Okay? All right, last word. We're finished. Osteoporosis. Anybody know anybody that has osteoporosis? If so, you want to be careful, but also treat them with pity because it's a degenerate disease. And so, anyway, and that, folks, I think we're pretty much on time. Thank you very much.